Often we use words and we read words and phrases and we sort of take them for granted, and we maybe don't really know what they mean. And that's particularly true of, let's say, bills of attainder and ex post facto laws. These are two prohibitions that are in the Constitution, in many state constitutions, and yet when we read them, we read over those prohibitions, but we don't know exactly what they mean. And so when you see a bill of attainder mentioned, what that means in a very general sense is that it's a legislative act in which a criminal act is specified, and it's directed toward a single or a group of individuals, and they are to be considered guilty of that crime without any judicial proceedings, no due process through a judicial institution whatsoever. And so this was used often in governments. It was used in England, and it was used in colonial America and in revolutionary America. And so most of the state constitutions, the new revolutionary state constitutions that were drafted, prohibited bills of attainder, either in the body of the Constitution or in attached bills of rights. Now, it's interesting to see the New York reference to bills of attainder. It says in the Constitution that bills of attainder will be prohibited after the revolution was over. And it sort of gives you a little clue as to the utility of bills of attainder in difficult periods of crises, and certainly in war. And so you find in colonial America, in revolutionary America, I should say, bills of attainder being regularly used by the revolutionary state governments, even though their new constitutions and bills of rights would prohibit them. This was a case of emergency that this happened. There was an interesting case in Virginia. There was a marauder who had a band of men, and they would go and kill patriots and rob from them. And the legislature then passed an act saying that this person was guilty of a crime and should be arrested and executed. And eventually he was arrested and he was executed. And so during the ratification debate over the Constitution, this issue was brought up. And so Federalists are saying, look, despite the fact that bills of attainder were prohibited in the Virginia Declaration of Rights, it was used. And so these paper barriers are not effective. So don't worry about having a Bill of Rights. The Anti-Federalists responded by saying, well, you're only partially right. He was, this marauder was indeed arrested under the Bill of Attainder, but he was given a fair trial, and he was found guilty at that trial, and he was executed because of the judicial verdict that was handed down. Eventually, when peace arrives, the courts are made more equitable, and bills of attainder are indeed eliminated. Ex post facto laws are a little bit simpler, I think. If someone commits an act when it's not illegal, it shouldn't be a crime. But sometimes the legislature would, after the fact, pass a law and retroactively say it would be a crime, even though when the person committed the act, it was not a crime. And so this is what is being meant by no ex post facto law. You cannot make an action that is not illegal when it's being perpetrated into a crime after the fact. Now, in the ratification debate, George Mason of Virginia, one of the three non-signers of the Constitution, he objected to the fact that there was a total prohibition of ex post facto laws. He wanted governments to have the power to pass ex post facto laws, not in criminal cases, he didn't want that, but in civil cases and in financial situations. The government should be able to change certain provisions after the fact. Well, Federalists responded saying ex post facto laws only apply to criminal cases, not to civil cases and not to financial cases. And so that was not a serious objection. So these two provisions are very important. They're disallowed under most state constitutions, and the federal government, the federal constitution, says that neither the states nor the federal government should have the power to pass bills of attainder or ex post facto laws.